Whoa!
I filed my eligible obligation.
What are you talking about? What are you talking about?
I'm talking about eligible obligation on the USCA.
Oh, you talking all that kind of stuff. I'm striking all that. If I hear it again, I'm not going to let you represent yourself. I promise you.
Oh.
That's enough. I don't want to hear another word.
Okay, I'd like to also...
Another one? I don't want to hear another word. No, put him out.
Put your hands on me like that.
Hush. Get him out of the courtroom. I don't want to hear another word. I just heard another word, Mr. Baker. Hush.
Hold on a second. What are you talking about? Eligible obligation. What's all this nonsense? I'm talking about my responsibilities under the law. Judge, we're clearly done here. If you keep bringing that up, I'm going to stop you right now. I'm not letting you represent yourself anymore. Understand? Enough is enough. Don't say another word. And don't touch me like that. Get him out of this courtroom. I don't want to hear another thing from him. All right, everyone, get ready, because we're about to see a perfect example of someone who's completely lost touch with reality. This is a person who's facing 30 years in prison, and they are not making things any easier on themselves.
All right, Mr. Baker, you're before the court today for your arraignment. And let's see. You're not... Have you hired an attorney?
No, sir.
Do you plan on hiring one?
No, sir.
Are you going to represent yourself, or do you wish to have a public defender to represent you?
No, sir. I'm going to represent myself.
All right, you're before the court today for your arraignment. You've been charged by way of an information with possession of a cocaine, possession of a controlled substance, count 1 and 2. Those are both third-degree felonies, punishable to 5 years in the Florida Department of Corrections and a $5,000 fine. You have a count 3, which is fleeing or attempting to elude high-speed reckless. I believe that should be a second-degree felony, punishable to 15 years in the Florida Department of Corrections and a $10,000 fine. Count 4 is drive my license, cancel, suspend, or revoke third or subsequent offense. That's a third-degree felony, punishable to 5 years in the Florida Department of Corrections and a $5,000 fine. And count 5, possession of marijuana less than 20 grams, which is a first-degree misdemeanor, punishable to 1 year in the county jail and a $1,000 fine. So you're looking at a total of about 30 years in the Florida Department of Corrections if you're convicted of everything and you get the maximum sentence. And you're still wishing to represent yourself?
Yes, sir.
Spoiler alert, things do not go well for him. The judge completely shuts him down in one of the most entertaining courtroom moments you'll ever see. It's wild. But here's the big question. Why on earth would anyone facing decades in prison choose this route? Seriously, who in their right mind tries to go it alone when the stakes are so high? I'd love to hear your thoughts in the comments. Let's break this down and see just how badly it all backfires for him. Judge, Mr. Baker, you're here today for your arraignment. Have you hired an attorney? Mr. Baker, no, sir. Judge, do you plan to hire one? Mr. Baker, no, sir. Judge, so, you want to represent yourself? Mr. Baker, yes, sir. Judge, all right, let's review the charges. You're charged with possession of cocaine and possession of a controlled substance. These are both third-degree felonies, which could mean up to 5 years in prison and a $5,000 fine.
Yes, sir.
All right, Mr. Baker, state your name.
Lee Baker.
And Mr. Baker, you have asked to represent yourself. Is that correct?
Yes.
How far did you get in school?
9th grade.
Okay. And so you can read and write?
Yes.
Okay. Are you employed?
No, sir.
All right. How do you make a living?
I'm unemployed right now. I was living with someone else.
Sir?
I'm unemployed. I was living with someone else. I just got out of jail about 5 months ago.
Okay. Well, what is your trade?
I have my own business.
All right. What kind of business?
A cleaning business.
Okay. And have you ever represented yourself before?
Yes.
All right. Let's see. Are you under the influence of any drugs or alcohol today, which would affect your ability to make this decision to represent yourself?
No.
Have you ever been diagnosed with a mental illness that would affect your ability to to make this decision?
No.
All right. You understand that attorneys are trained in the rules of evidence, criminal procedure, and the law, and they're there to assist you in preparing pretrial motions, preparing for pretrial hearings, and to participate in discovery, and also preparing for trial.
Comprehend that very well.
All right, and sir, you understand that if you're representing yourself, you'll be held to that same standard.
I comprehend that.
All right, and I cannot assist you in any way. The state attorney would not be able to assist you in any way. Is that correct?
I comprehend.
All right, you still wish to represent yourself?
Yes.
All right, Madam Clerk, if you'll print out the information, and Deputy Dexter, it's okay if the clerk hands the information to Mr. Baker? Madam Clerk, if you'll do that. Mr. Baker, when you receive that information, I'm going to ask that you enter a plea at this time.
I'd like to file 2 motions on the record as well, sir.
I want to do your arraignment for. All right, whenever you're ready, you'll let me know and you enter your plea.
I enter a plea of not guilty.
Okay. All right, you're filing motions?
Yes, sir.
You have copies for the state?
Yes, I do.
Okay.
Got a declaratory judgment, and I want to furnish this bond to the clerk.
You file it. Go ahead.
For my release from the Bay County Jail today.
Okay.
That's declaratory judgment. That's for the clerk only.
Now, you're providing a copy of the state, everything you've given the clerk?
The bond, I shouldn't have to give the bond. The bond goes straight to the clerk.
Anything you file that you want me to consider, you have to provide a copy to the state, sir. As you're representing yourself, you have to know those rules. If you don't, you're going to mess up.
That.
If you're not providing to the state, I'm not going to consider it.
Okay.
And the clerk doesn't make any determinations on that. All the clerk determines is whether you're innocent or not.
I'm not talking about the bond for the declaratory judgment. I'm talking about the bond for the clerk to release me today. I filed my eligible obligation.
What are you talking about?
Sir?
What are you talking about?
I'm talking about an eligible obligation. On the USCA.
Oh, you talking all that kind of stuff. I'm striking all that. And if I hear it again, I'm not going to let you represent yourself. I promise you.
The 5th charge is possession of less than 20 grams of marijuana, which is a first-degree misdemeanor. That carries a year in jail and a $1,000 fine, Judge. So, if convicted and sentenced to the maximum on all charges, you're looking at about 30 years in prison. And you're still choosing to represent yourself? Let's be honest, how do you look a judge in the eye after hearing you could be facing 30 years and still think, nah, I got this? I just don't get it. I understand why some people try the whole sovereign citizen thing for a speeding ticket. It's silly, but it doesn't carry much weight. But when you're looking at 30 years behind bars, you need to snap out of it. Drop the act before it's too late. That sovereign citizen nonsense doesn't work in court. They don't care about your made-up laws. Legally, every time someone tries it, it's been shot down.
He's already entered a not guilty plea. We'll set this for a free trial. We'll set it for a... Don't ask me any questions like that, sir. I'm not answering any questions. If you want to file a motion, file your motion. We'll set it for our December... When's that motion day in December? December 19th at 9 o'clock. Sir, you may... If you're going to do the sovereign citizen and all that, you may want to consider having the attorney...
I'm a private citizen, sir. I'm not a sovereign citizen. I'm a private citizen.
Listen to me. If you're going to pursue that, you may want to reconsider representing yourself.
No, sir.
But I'm not going to pay attention to any of that, and I'm going to strike all that.
Okay.
So we'll see you December 19th at 9 o'clock.
It's no problem.
That's enough. I don't want to hear another word.
Okay, I'd like to also...
Another one? I don't want to hear another word. No, put him out.
Put your hands on me like that.
Hush. Get him out of the courtroom. I don't want to hear another word. I just heard another word, Mr. Baker. Hush. Whoa. Mr. Baker, I'm going to appoint the Office of Public Defender to represent you. I'm going to find that you're not competent to represent yourself at this time. I'm going to reverse my decision. The Office of Public Defender is going to represent him. We'll keep it on that December 19th date. I just did. Come on now. Y'all close that door where I can't hear him.
Judge, Mr. Baker, do you plan on hiring a lawyer? Mr. Baker, no, sir. Judge, so, you want to represent yourself? Mr. Baker, yes, sir. Judge, all right, let's go over your charges. You're facing possession of cocaine and possession of a controlled substance, both third-degree felonies, which could get you up to 5 years in prison and a $5,000 fine. Charge 3 is fleeing from the police with reckless driving, a second-degree felony, which could lead to 15 years in prison and a $10,000 fine. Charge 4 is driving with a suspended license, a third-degree felony, with up to 5 years and another $5,000 fine. Charge 5 is possession of less than 20 grams of marijuana, a first-degree misdemeanor, which could lead to a year in jail and a $1,000 fine. Judge, so, If convicted on all counts, you're facing up to 30 years in prison. Are you sure you want to represent yourself? Now here's where it gets interesting. This guy is sitting in front of a judge, looking at the possibility of spending 30 years in prison, and still thinks he's got this. He starts pulling out the sovereign citizen nonsense, using terms like eligible obligation and USCA, which stands for United States Code Annotated, a collection of laws with extra notes. He's dropping all this legal jargon, thinking the judge will be impressed and let him off the hook. Let's be clear, this isn't how the law works. Eligible obligation is just a made-up idea that sovereign citizens love to talk about. They believe they can erase debts and charges just by using the right words. But guess what? Courts have rejected this idea over and over again. It never works. Yet, here he is, trying it anyway.